Let's kick off this explainer with a pretty wild question. Can forwarding a simple cartoon or an academic article on social media actually lead to prison time? I mean, it's something millions of us do every single day without a second thought. But as we're about to see, in certain contexts, that simple tap of a button can ignite a massive, highly complex legal drama. So welcome to the explainer. Today, we're unpacking a really fascinating, politically charged criminal case. But we're doing it through a totally unique lens. We're going to look at how 6 distinct, globally recognized AI language models evaluated this exact situation using the framework of international human rights law. Here's our roadmap for today. We'll start with the case of Dr. Chen, then look at the court's conviction logic, move on to international law and the ICESCR, break down the AI legal consensus, and finally explore the broader chilling effect. Part 1. The case of Dr. Chen, from online forwarding to prison. Let's trace his digital footprint. For 3 years, right from 2019 to 2022, Dr. Chen was just quietly forwarding online posts. Nothing crazy. Then, suddenly, in September 2022, police entered his home and arrested him. Fast forward to January 2023, he was formally indicted for picking quarrels and provoking trouble. Later that same year, after a closed-door trial, where, by the way, he wasn't allowed self-defense and his family couldn't even attend, he was slapped with a sentence of 1 year and 8 months in prison. What's truly mind-blowing here is the absolute micro-scale of this so-called crime. Get this. Dr. Chen is a PhD in complex systems physics. He used a VPN to get around digital firewalls and forwarded posts on a chat app to an audience of fewer than 100 followers. And honestly, most of those were just inactive zombie accounts anyway. He was sharing academic articles, diplomatic posts, political commentary. He even forwarded a symbolic cartoon known as the Umbrella Girl. His total lifetime forwards on this platform? Under 100. We are literally talking about everyday digital curation to a tiny, almost non-existent audience. Part 2. The court's conviction logic. Picking quarrels and provoking trouble. Now, this brilliantly illustrates the court's core logic. On one hand, they actually used his high academic status against him. The court argued that because he has a PhD, he should have known the content was false, basically presuming malicious intent right out of the gate. And on the flip side, they labeled the simple act of forwarding these posts to a handful of followers as causing severe chaos in public order. To be perfectly precise, let's look at the court's exact words. They stated, quote, "The defendant has a high educational and knowledge level, should distinguish right from wrong, knew they were insults, attacks, and false information, causing severe chaos in public order," end quote. That's exactly how the domestic judicial system officially classified his curation of art and academic posts. They framed it as a deliberate, harmful distribution of false information. Part 3. International law and the ICESCR. A different legal lens. Now, it's super important to establish that evaluating this case under the ICESCR isn't just some arbitrary choice we made. The International Covenant on Economic, Social, and Cultural Rights is a core UN human rights treaty. China signed it in 1997 and ratified it in 2001. That means it carries binding international obligations that the domestic judicial system is absolutely expected to respect. The crucial point here is that these specific articles basically form a shield around the exact activities Dr. Chen was doing. Article 15 protects his right to participate in cultural life, while Article 13 safeguards his academic freedom. Throw in Article 2's protection against political discrimination, and Article 6's right to freely chosen work, and, well, you've got a pretty robust international defense for his digital curation. Part 4. The AI legal consensus. 6 language models analyze the case. This is where it gets incredibly interesting. When tasked with analyzing this case, a striking, unanimous consensus emerged across the board. Whether it was ChatGPT focusing on improper criminalization, Copilot calling out the discriminatory presumption against his PhD, or DeepSeek, Gemini, Grok, and Qwen all identifying severe violations of cultural rights, every single AI model independently concluded that Dr. Chen's rights under the ICESCR were undeniably violated. The AIs were quick to highlight a really fundamental mismatch. The domestic court treated art and academic opinion as literal facts that could just be labeled false information or rumors. But the AI models, applying the ICSCR, universally pointed out that subjective art, like that Umbrella Girl cartoon, and theoretical academic opinions literally cannot be scientifically proven true or false. Because of that, they're protected forms of cultural expression and scientific research, not rumors. Furthermore,
Every single one of these AI models flagged a major violation of the principle of proportionality. Now, if you're not familiar, this is an international legal doctrine stating that a punishment has to fit the crime, and any restriction on rights must be strictly necessary and minimal. Slapping a scholar with a nearly 2-year prison sentence for merely forwarding posts to fewer than 100 followers, yeah, that massively fails the proportionality test.
Part 5. The chilling effect. The macro impact on society. The models all warned that punishing one single scholar's digital reading history creates a highly dangerous ripple effect. DeepSeek noted it generates intense fear and self-censorship. Gemini warned it actually destroys a society's self-correcting ability by eliminating academic debate. Copilot and Quen pointed out that this stalls scientific progress and cultural life entirely, which violates the state's positive duty to foster a free scientific environment. So, you see, this isn't just about one man, it's about the erosion of the entire intellectual ecosystem we all rely on.
To really crystallize the stakes of criminalizing academic curiosity, let's listen to this incredibly powerful quote directly from the Quen AI model's analysis. It states, "Criminalizing these activities not only harms the individual, but may systematically suppress the entire knowledge community." That is a heavy realization.
And that brings us to a rather provocative thought to close out this explainer. If an independent scholar's digital reading history, their passive curation of art and global opinions can be officially prosecuted as a severe threat to public order, well, where exactly do we draw the line? Where's the boundary between maintaining societal stability and suppressing the very mechanisms of human advancement? It's a delicate, high-stakes balance of international human rights that ultimately affects every single one of us who clicks forward online. Thanks so much for joining me on this explainer, and keep questioning.